listening to Estate at the Union, estate planning made simple. Here's your host, Brad Wiewel, from Texas Trust Law in Austin, Texas.
Good morning, everyone. My name is Zach Wiewel. I'm on Estate of the Union podcast, filling in for Brad Wiewel. I'm joined today with Miss Ann Lumley. How's it going, Ann?
Good, thank you very much.
Yeah, we're excited to talk to you guys today on Friday the 13th about choosing the right trustee. And what we're going to talk about is just some considerations you should really just think hard about to make sure that the person you pick to manage things when you can't is the right person, is going to be the right fit. And Ann, my first question for you, because we have a lot of clients in Texas, but their kids live all over, or their loved ones who they want to manage things live all over. Does geography matter for choosing a trustee?
I'm going to give you the typical lawyer answer of it depends,
Okay.
which I'm sure people don't like to hear. Sometimes it's very convenient to have someone that's local because there are days that you need to show up actually at the bank. We can do administrations with trustees living in another state. It can be more complicated sometimes, but it's definitely doable. But one thing to really consider are the laws of the state that the trustee lives in, because in some states like California, by having a California trustee, even of a Texas trust, you're exposing that trust to California income tax. And so there may be reasons to not choose someone in a certain state versus having a Texas resident, but it is definitely doable that you can administer.
Well, I guess a question kind of related to that, we didn't talk about this one ahead of time, is let's say that someone has a bank account at like a smaller institution, regional institution. Would that trustee have to travel to that institution, or can they do it all remotely, or does it kind of depend?
It does depend.
Okay.
I've seen both. Even with a larger bank such as Wells Fargo, we had co-trustees, and one of them did live in California, and one was in Colorado. And Wells Fargo was requiring them to show up in person. They wanted them to do it together. That wasn't going to be possible.
Yeah.
We arranged someone at the Colorado Wells Fargo to be present on the phone with someone who's at the California Wells Fargo, and then the siblings went in and had to show their identification together, and we were able to kind of work it out that way. So it worked out, but it was a little more complicated. Sometimes banks need you to come in person to check your ID and get you to fill out signature cards, but there are other types of financial institutions that we can do things just in packets through the mail, and they don't require the in-person identification.
Yeah, and just a note on that too, because I've had a couple of clients come in recently who their loved ones who they want to administer things live overseas. They're not U.S. citizens. The parents might be U.S. citizens, but the kids aren't, or the loved ones aren't. Does that cause any issues on your end? I know it does.
You know it does, because we had a case like this,
Yeah, we
and you actually, with your tax background, pointed out, there are international tax implications having a foreign trustee. And so there are a lot of things to consider. Geographic location is one. It can be easier, like we said, to have someone local for different reasons. It can be possible to have them other places, but you need to make sure that you're looking at all of the pros and cons before you choose.
Yeah, and we'll talk about this in a little bit, but trust companies are a pretty good way to solve that if you do have all your people living overseas. My next kind of thing I want to talk about with you is family dynamics. Whether and who you appoint, if it's going to be a loved one, their relationships with each other and their own kind of personal, who they are. What makes a good trustee in terms of family relationships and their kind of work ethic or how they approach doing a job?
You need someone that's able to navigate the family dynamics and keep the peace. You want to consider, a lot of times parents want to have siblings be a trustee for another sibling, and you may be putting them in an awkward position where they're having to say no to a brother or sister because they might not be making great financial choices. But as a trustee, you have a fiduciary duty to act in that beneficiary's best interest. And so you could be unknowingly creating conflict within your family, and you don't want to do that. But if you have siblings with a good dynamic and well, in the one case that I was mentioning before, they were siblings and they were co-trustees. They did consider having the one that was in California not be a trustee and have the
Just to
sister
avoid all those issues.
to avoid the tax issues, but they they didn't have that kind of relationship, and ultimately like, no, I'm not going to resign. I want to be my own trustee. But same situation. I had a different case, and the one that was a trustee in California was actually an attorney and would seem to be a great pick, but he didn't want the tax consequences, and he did allow his brother to be the trustee, and they did just fine. So it does depend on each person and their dynamic, but it's something you really want to think about, because you could unknowingly be causing more drama than you want for your family.
Yeah, and one thing on that too, in terms of like the personality of the trustee that you're picking, what I typically tell clients when we're designing out a plan is you want someone who can kind of get stuff done. It might not be like right away, but they schedule it into their calendar. They're good at like project management. Is that, in your experience, has that been?
That's a blessing, because I work with all types of trustees. In some cases, we move through rather quickly because they're on top of it and they do their part, what we ask them to do, and we can move through administration pretty quickly. But even if someone may, on paper, look to be a great trustee, they have the perfect skill set, they might be too busy, because it does take time to administer a trust, and it's an ongoing obligation, and you do have fiduciary responsibilities. So you might want to consider how busy. You might have a financial advisor son that may look to be a perfect trustee, but they might be too busy in their job, but maybe there's someone that can be consulted or something like that. So you just need to take all kinds of things into perspective.
Yeah, because it takes time to administer this stuff. And again, scheduling it or scheduling an hour to a week, if that really does help. But, you know, if one of your daughters just had a baby or raising multiple young kids, maybe at least for now you appoint someone else because she's got enough on her plate as it is.
Right, it might be too much to ask of someone.
Exactly. And since you brought it up, let's go ahead and talk about co-trustees. Do you like co-trustees?
I prefer a single person to represent, but I have represented co-trustees, and again, it depends on the dynamic between the two. I know that a first choice would not be to have co-trustees, because you're having two people having to agree on financial decisions, and it can delay the process. If they're in different states, I have another case right now. Two brothers are co-trustees in different states, and we're trying to get some paperwork into a financial company, and it's just causing some delays because we have to send it out to get notarized to the two different states, and then have them returned and create a full packet to move forward. So it's possible, but it's not always the easiest path.
Yeah. The way I kind of view it when I'm talking with clients is I have two older brothers. I love them dearly. Neither of them are lawyers. They're too smart to go to law school. But I've never, ever worked on a group project with them. And I'm not sure they'd be the best people to work with on a group project. No offense. And so, like, for me and my family and my dynamics, obviously I'm probably the best fit because this is what I do for a living, but I wouldn't necessarily want my brothers to hop on to have 50-50 decision-making authority. I'm still going to get the inheritance to them in the right way, in the right amounts, but it can be tough to decide, because if you're a co-trustee, you kind of have to decide everything the same way. Have you ever had like a case where people disagreed on a decision?
I have. I have. It doesn't quite fit what you're asking me in this situation, but it was actually over tangible personal property, and it would involve
so like
painting.
Your jewelry, your painting.
It was a piece of art, and they couldn't agree on what to do with it. We ultimately had the artwork professionally copied, and then they flipped a coin on who got the original or how to get rid of it. So it's not quite what you're asking me, but yes, I've had times when they didn't quite agree on what to do, and it pauses the ability to move forward. Even if our trusts that we're administering say that one trustee can act without the authority or consent of the other, so that both trustees don't have to sign.
Yeah, they can one can sign a check to pay for a bill. They both don't have to sign the check.
Right, but even though the trust does say that, sometimes during the administration, it's the financial institution or the title company's policy. They want everyone to sign anyway, and so it can.
It's kind of like best practices. To
so
see
it can cause delays and some issues.
And we have, I mean, just for everyone listening, we have conflict resolution provisions all throughout it, so that way they're not stuck going to court unless they're really just trying to go at each other. But yeah, there are conflict resolution mechanisms built into every trust, but what you mentioned earlier, the word you use, it pauses. You have to pause until this decision's resolved, and that just takes time. And people don't want to spend more time than they have to. Yeah, and sometimes money.
Extra money to get to a resolution too. So it's just stuff to consider when you're picking your trustee.
Yeah. And then kind of the next thing I wanted to run through with you was kind of the mechanics of being a trustee. So let's say your parents passed away and you're administering the trust. You have to pay if there's a mortgage, you got to pay the mortgage, keep that running. Got to pay the credit card bills off, or the car loan, or just property taxes. You got to keep paying stuff. What should the trustee do to keep track of all that stuff?
Take very good financial records. Keep very good financial records. You owe complete transparency to the beneficiaries, and you owe them a fiduciary duty. And by law, any beneficiary of a trust can request a formal accounting of all of the trust funds at any time within a year, and you have to produce that pretty quickly. And so it's always best practice to keep very good records of where things are going, so that if anybody has any questions, you can show that you've been acting in their best interest. Yeah,
I think because the first 2 or so years of my practice here, all I did was help you and kind of learn the ropes from your perspective. And I think we got like 1 or 2 requests for accounting or something like that. And you know, when you get one, I think it's either 60 days or 90 days you have to produce those records. And it can be a huge pain. It's always a huge pain, but you can make it less of a pain by just keeping good records.
Right.
Yeah.
So you can get that put together a lot easier if you've already been keeping those records. If you have to go back and dig through and create them for the first time, it's sometimes hard to meet that deadline. I believe it is 60 days from a formal request.
Yeah, and the way I kind of view being a trustee while you're serving is it's not like a business, but you should be keeping records like a business. Like if I have an expense here, I get a receipts, I put it somewhere safe where our bookkeeper, keeps track of it. It doesn't have to be as intense as hiring a bookkeeper, but it's the same thing as just keep track of what you're doing, so that way if you request, because most people don't actually request one, but if you request, you can just provide it within the timeline.
Yes.
Yeah. And this is going back to something we talked about earlier, and that's corporate trustees. So by corporate trustees, I mean you don't want to have an individual serve. You want to have like a bank, a trust company, some third-party professional serving. I know you've worked with a lot of trust companies over is it 11 years now here?
12.
12?
12 now. Just now, 12, I think.
Oh, happy anniversary.
Oh, thank you. Yeah. Yes, June.
Yeah, okay, happy, okay. So what's been your experience like generally with corporate trust companies?
I've had a positive experience with trust companies over the course of, I've worked with them in different roles. I've worked with them as trustee of, we represented them as trustee. So we were the trust company's attorney during the administrative process to make sure that they moved through the process correctly. And I've worked with them where they were the trustee and had their own inside counsel guiding them, but we represented the executor of a probate estate and had to get those probate assets over to the trustee. So we've interacted that way. And I've had real positive experiences with them, and they are often necessary in some situations. Sometimes people don't have anyone that they can name, and they need to rely on that. And sometimes if there's special needs involved, it's better to have a corporation so that you don't violate.
You don't disqualify them for Medicaid or whatever.
Exactly. You don't want to make any poor decisions as trustee to disqualify a beneficiary. The biggest hurdle is sometimes time at the beginning, because a corporate trustee has to accept. They may be named trustee, but they have to accept the trusteeship. And I know that there can be a long formal process where they review all the assets, they review the trust, and in the meantime, there's still expenses that need to be paid. So I think it's faster to get an individual the documentation that they need to keep a smoother transaction in an administration. But corporate trustees are necessary and good. Just know that there may be some delay, and there's no guarantee they're going to accept the trusteeship. We do our best to have language to meet trustee, corporate trustee requirements so that to make it a smooth transaction, but you don't always know when someone's going to pass away or what the requirements are going to be at that time, and they need to review it before they accept it.
So it's kind of like you're balancing speed to administer all this stuff, at least right away, to get access to start paying bills or, you know, pay for the funeral cost. You're balancing that initial speed for a professionalism, for someone whose job full-time is doing this.
Right, and that might be the option. If you have siblings, and maybe one of them is good with managing money and the other one's not, but you don't want the one that is good with managing money having to deal with their sibling, like we were talking about, the family dynamics might be strained. You know, a corporate fiduciary is a great alternative because they're asking that corporation to make a distribution, not their sibling. And so they're not having resentment towards their sibling for not getting money for something that might not be really within the realms of their trust.
It's kind of like, and sometimes it's unavoidable, but as much or as little ongoing entanglement between siblings, I think the better. Again, sometimes you can't really avoid it, but when you can, like, it's best to not split the house between two different loved ones, but give one house to one loved one, give an equal amount of cash or something else to the other one, because there's that same entanglement kind of on a long-term basis whenever you kind of do that.
Right, and so you meet with people making these plans and you help them think through these different considerations while they're making these choices, which is great because I just see things after someone's passed away. I always tell people, I know you don't want to meet with me. Nobody wants to meet with me. If you're meeting with me, something's happened to someone you care about. And we try to be mindful and respectful of that, but that adds a whole other layer to everything because you're grieving. And there's a lot of anger in grieving too, and it can come out in different places. And so it adds to the conflict. So if you've already pre-thought about some of these potentially sticky situations and have put into your document ways to avoid some of that, you can make on an emotional level, the administration as easy as possible by eliminating some of those issues ahead of time.
Yeah, no, that's a good point. That's a good point. I have a question for you. I didn't bring it up ahead of time.
Oh, I would love surprises, Zach.
What's your biggest pet peeve? So you're helping administer a trust and you're working with a trustee. What's your biggest pet peeve whenever something like when you're helping them?
I can understand that there's different types of personalities, and sometimes people like to take action, but I don't prefer people to take action without being requested to do so. Sometimes they take the reins a little too fast, and we have to unwind some things.
Yes, we do.
I have I have a trustee that, with the best of intentions, was trying to appease a sibling and get them their share, but they were supposed to receive it in a separate share trust with certain protections. And we're having to unwind some of that because they made a distribution
before everything was
without
set up
me
the
knowing
right way.
it too soon. And so we're trying to fix that right now. And it may involve a whole other layer with like a family distribution agreement and more legal work and more expense. So I like it when they let me do my job to help them do their job.
Yeah, I think that's how the folks listening should kind of view our role in this administrative process, because we're not serving as trustee, but we're representing the trustee. And for a lot of these people, this is their first time ever doing something like this.
Yes.
And, you know, we do a good job at the start and even beforehand trying to get them up to speed, giving them materials or the knowledge they need to do it. But they got to do it. But we're kind of like their Sherpa, their guardian angel, guiding them through the process. So if they make a distribution too quickly, okay, well, shouldn't have done that. It's okay. We're going to fix it. But we're just kind of guiding them along so that way they don't do anything they're not supposed to do.
Right, and it's definitely it's a process, and it's a process that we do very well, and over years have figured out the best way to move through. And so yes, our job is to guide them through the process and get them to the end of the game as smoothly and quickly as possible. But sometimes, with the best of intentions, it's
almost always with the best of intentions.
Yes. Almost always.
Almost.
And sometimes we have to withdraw because they weren't the best intentions. But yes, most of the time, that's what it is. And we just have to, like, it just adds a little kink, and we can usually fix everything, but it might. what seemed to try to speed something along could unintentionally make it take longer because you have to go back around and unwind some things and redo it.
No, I won't say the name, but I think of a couple situations very specifically about that. So what do you think my biggest pet peeve is?
Goodness, Zach, I don't
I'm
know.
sorry. This is mine. And it happens for whatever reason, and it's fine. It's just when we start representing the trustee, we're taking them through this process, making sure they're staying within the lines, and again, doing their job the right way, the way that the grantors, the people who are giving away the money, intended. But one of the things that just really, I'm just like, can we not, what?
Non-responsiveness?
Non-responsiveness. You know, you send an email, you give the trustee deadlines, and they're usually soft deadlines. Like, it doesn't usually have to be done on this date or by this date, but you don't get a response back, and then you follow up, you call them, and you just get ghosted. Sometimes
that's very hard.
Yeah, I think sometimes it went on for almost a year. It happens.
I have some now. We need certain things in order for us to do our job, and we can't do, I don't like to have the ball in my court. So when something's on me, I want to get it done as quickly as possible and move it to the next person in the process. But sometimes we get stuck because that person's not doing theirs. We try to prompt and and move things along. But yes, that's definitely difficult. And then they don't understand why the administration process is taking so long, but we're waiting on them so we can keep moving along. So that is a pet peeve and a challenge.
Yes, it is. And sometimes it actually causes issues. You just wait too long, and they miss a tax return, they miss something, and it's just, okay, now we have to spend more of our time, and it's less about the fees, because there might be additional fees from the time, but it's just, what I tell clients is, as quick as the trustee you appoints will work is about as quick as it will go. If they're on it, if they're getting stuff, if they're on top of it, for the most part, it goes pretty quick, unless we're doing like a tax return or something, like a 706 tax return. But yeah, it stinks whenever they just don't respond to you.
Well, I try to manage people's expectations. We talk about time commitments when, and it takes, on the average, I think I even Googled once, like, what's the average trust administration, just to see if I had a generic perspective. I mean, I have my professional perspective, but what is out there? And it said about 1 year to 2, and that's pretty accurate. It can take a year, sometimes more, depending on the complexity of how the assets are structured and the complexity of the trust. Are you splitting it into sub-trusts? Is it all going to one?
Is one kid not responding?
Exactly. I've administered trusts in 2 to 3 months that could take that long, but people are on top of it, and we just keep moving. And I've administered some that have taken a couple years, and then it just depends. But I try to let people know we'll move as quickly as you allow us to, and as the financial institutions allow us to, because there are often third parties involved that I have no control over how quickly or accurately they respond.
No, the favorite cases I helped you with are the ones where the trustee is just on it. He or she goes to the bank within a reasonable period of time. They get the requested things that we asked for. They send it back. It makes the process just go so much smoother, so much quicker. But when it doesn't happen, it's frustrating. I guess a couple more questions for you, Ann, before we wrap up for today. What's your favorite part about your job?
I like making it easier for my clients. They just lost someone. They come to me overwhelmed. They're grieving. This is complex law. I would honestly say doing only administrations, because the way our firm works, I pretty much only do administrations, and I think it took me about 3 years of only doing administrations to see all the different variables of facts and things that could happen to really kind of grasp a bigger picture about it. But when I meet with someone for the first time, I have to talk to them about a lot of things that might not apply to them in their specific case, but involve time limits and choices in their role as trustee, so they have to know about it to be informed. Like estate tax. A lot of people don't have to worry about estate tax right now because of such a high exempt amount, but there are other reasons to file an estate tax return that they need to know about as a trustee, because it may be in the beneficiary's best interest to go ahead and do so. So they're grieving. they're not sure what's going to happen moving forward, and then I'm bombarding them with a 2 to 3 hour meeting with complex legal concepts, and I can just see the relief when I'm like, I'm pretty much going to guide you through this process. If you have to make a decision, I'll tell you the pros and cons, and you make the decision. Otherwise, you sign here, and I help guide you to get everything where it's supposed to be. And just the relief that people feel that they don't have to carry that burden, and they can rely on us to get them through it.
And you bring up something to the estate tax. I mentioned it earlier, the 706. Again, most people today are not subject to it unless you're worth more than 14 or 28 million.
As a couple, yeah.
As a couple, yeah. And if the big, beautiful bill passes, it'll stay around those levels. But if it doesn't pass, it's going to drop to about 7 million per single person, 14 million per couple. And you've worked on a few 706s, I've worked on a few. Does that drag out the process a little bit?
Having a 706 involved? It depends on the type of trust that we're administering, and if it's what we call the AB split trust, where we're putting the decedent's share into a marital trust and the survivor's share in a survivor's trust, and you're choosing to do an estate tax return for the Q-tip qualified terminal interest in property election. I know we're getting pretty technical here, but there's a reason why you do that. And when you do it that way, you need to be in good coordination with the tax preparer, the CPA or attorney doing the estate tax return, because you need to know which assets are allocated to that trust. And so we want our values to match what's on the IRS tax return, and we want to make sure that how we've proposed the split of assets matches what's put on the estate tax return. So it can draw out the administration, because you have 15 months to get that in with the extension. And so we might not get the values and things we need from the tax preparer until later on in the process. And so it can make it take a little longer to administer an estate. But some trusts don't split, and we don't have to coordinate that aspect of it. And so we can do our part and still be finished with that part of the administration while they're waiting to file the tax return.
Yeah, I think when you're in the taxable situation, not all of our clients are, some of our clients are, or a potentially taxable situation, who you choose as trustee in terms of responsiveness it just matters more, because there's more work for them to do when they have to file that tax return within up to 15 months. And if you're not at those levels, but you're still filing the tax return, you have 5 years. So there's more breathing room, but if you're pretty dang sure you're going to be taxable, you are taxable over those thresholds, choosing the trustee with speed matters just so much more, because if you miss that deadline, there's penalties.
And there's often, with that type of an estate, a necessity to have like business evaluations and real estate appraisals. And
those take a lot of time.
Yes, they take a lot of time, and you want to get them started so you don't miss any deadlines.
Yeah. Last question for you, Ann, and this is just because a lot of our clients are in this situation, is do you find it helpful for clients when, like, the first spouse dies and one of the children or one of their loved ones, their sibling, comes on with their parent, their brother, as a co-trustee? Do you see that a lot?
I do see it, and it depends on the dynamics. I've seen it work just fine, and I've seen them have a hard time agreeing on things. I thought you were going to ask me if I like it when they come to the initial meeting.
Well, do you like that too?
I do like that, and I do also like it when they bring their financial advisors or their CPAs,
so much.
because it helps.
Oh my gosh.
Financial advisors are very helpful too, and they want to move things along quickly, but sometimes they don't understand some of the delays that we have legally before we can take that next step. And so it's nice to have everybody on the same page. So I do enjoy. It makes the meeting a little longer sometimes, because there's all the more questions to answer.
But that just means it's going to take shorter later, because they're all up to speed.
That's exactly right. And so we all have a game plan and can work together. And we do work with financial advisors and CPAs all the time, because we all play a different role. And we all, like, we don't give tax or financial advice, we'll give the legal advice, but we want to get them in. So even when we have like a split trust like we were talking about, we'll propose a split, but we'll have a meeting with the financial advisor and the CPA and the client, and so they can get all perspectives before they approve it. And we sometimes adjust, our split so that it fits everybody's the best interest of the clients and the beneficiaries.
Well, Ann, thank you so much for joining us today on a State of the Union podcast. Thank you, everyone, for listening. I hope you all have a great day. Thanks.